Let me start. I'm Irakli Kordzahia, member of the group of independent lawyer, also member of International Network for Judicial Reformers. Welcome everybody who joined this event and discussion, online discussion. International Network of Judicial Reformers continues its series and events and discussions about judicial reforms, sharing experience between representatives of different countries. So today's discussion topic is the role of private lawyers and bar associations in judicial reforms. This discussion will be moderated by Jim Moliterno, Professor Emeritus, Washington and Lee University School of Law, and rule of law consultant. I have the great honor and privilege to work with Jim on the topics of today's discussion in Georgia. We worked in Georgian Bar Association on Code of Professional Ethics of Lawyers, an amendment to the code, also on disciplinary proceedings. Created, Jim was leading creation of legal ethics opinions opinions institute in Georgian Bar Association. Jim also worked with Association of Arbitrators of Georgia and Association of Mediators of Georgia to create code of disciplinary code of conduct and disciplinary procedure. So I just touched only tiny portion of Jim's experience related to Georgia, and I know that there's a dozen of countries when he was involved in judicial reforms on with various stakeholders. So I will not go further. I don't want to take another 5-10 minutes to describe Jim's experience. So Jim, is floor is yours. You can we'll wait for your moderation and leading the very interesting discussion related to the role of private lawyers and bar associations.
Okay, thank you, Irakli. Thank you very much. And I should say it has been a great pleasure for me to work with you over the many years that we have had collaborations. It has been a long time, maybe 15 years that we have worked together on various projects, and it has been every moment of working with you has been a great joy. So it's a small crowd so far. I think I should say I hope some others will be joining us as we go along, but even if not, it's worth mentioning that we are recording this session, and I'm sure that many people who couldn't make it this morning or afternoon and will wind up watching this in the video that will go out to everybody who is in the group. And I wanted to say just a word about this group, the International Network of Judicial Reformers, before we start, for anybody who's not familiar. I'm really proud, I have to say, proud and happy both to be to have had a role in its beginnings, in its foundation. And it really started during COVID with a small group of reformers in Georgia. A few of them are on this screen right now. I see Kaka, I see Heka's name, Irakli. But it started with a small group of reformers in Georgia who were very passionate about making positive change and trying to make their judiciary work better. And to do that, one step that we decided together that we would take would be to try to expand and create an international network of people interested in judicial reform so that we could learn from each other. We could learn techniques. We could learn various models that might make judiciaries work better for the people of their countries. The group from the small number at the beginning expanded, and today it is a great many people in a great many countries. And I want to say that it includes people with many different roles and expertise. And it's a really very rich intellectual group, and a very practical group, a group that wants practical solutions, not just to talk about theories, but to talk about what can we do in very practical terms. I've always known that no one person and no one technique or model or anything like that can do everything to make change, to make things work better. But we all, it seems to me, need to contribute what we can, what we are able to do, and what individual techniques and models and activities that we can engage in. So in prior discussions in this group, this very group, we've heard about the role that civil society can play. We've heard about many different kinds of proposed changes in legislation and how they can improve a judiciary. We have heard about better vetting procedures for new judges, and so on and so on and so on. Many different ideas that we have been able to share in this network. And today, it seems to me, is just one more piece of the puzzle. What, if anything, can private lawyers do? Advocates, not judges. What can they do, both in their societies, but more importantly, I think, individually, as reform-minded people? So that's what today is about. It's really just one more piece of this puzzle. I will say just a word or two about bar associations, but there frankly is not too much to say. And then I will introduce and turn it over to our three expert speakers. So bar associations, in my experience, especially outside the US, are very disappointing in terms of their efforts in judicial reform. There are places, I have learned in asking friends and in work in different parts of Central and Eastern Europe, there are places where bar association as an entity has some formal role, is put into a position to send a representative to bodies that select new judges, to consider reform proposals that are before the parliament, and so forth. But in my conversations with friends and colleagues around Central and Eastern Europe, I have not learned of a place yet. I would love to learn of it. If you know it and you can tell me, I will be grateful. I have not learned of a place where the bar association as an entity really functions and serves an aggressive role in reforming judiciaries. Instead, they play along for the most part. They have a tendency to be relatively conservative and not try to change the system. In the US, maybe some of you know that historically and traditionally, the American Bar Association has played a significant role in the selection of federal judges. So when a president nominates a person for a federal court clerk, federal judgeship, especially for the Supreme Court, the American Bar Association has a process, and it gives a grade, if you will, for that person. Now, they only study their background. They only study what is publicly available. So it is not a deep examination, but at least there is some role. But nonetheless, I have to say that bar associations, even in the US, do not do much in terms of reforming the judiciary, of making change in the way the judiciary functions. So in a way, to me, bar associations could do a great deal. They could be a voice for positive change in judiciaries, but so far, at least in my experience, they have not really done that. So we can hope and we can advocate with people who are very active in bar associations that they take on a bigger role in some way. Okay, so I'm now going to move to our three expert speakers, and each of them will have the floor for about 20 minutes. If they finish their remarks before 20 minutes, we'll take questions specifically for them. But if not, if they use up their 20 minutes, we'll move on to the next speaker and the next speaker. And we have a good bit of time in the agenda that you can see on the screen. We have a good bit of time allocated when the three of them finish for questions and answers. And I can say that in the context of other of these online discussions, the question and answer is often very, very powerful and fruitful. It is where we are sharing ideas to a great extent. So we don't want to limit that time if we can help it. So I will give brief introductions of our three speakers. Then I will turn it over to them, 1, 2, and 3, and we will be on. So our first speaker today is a friend, Vítězslav Donal. He graduated from the Faculty of Law at Masaryk University in Brno in 1997. Right away, he was the co-founder of the Environmental Law Service. So he began in essentially public-minded, public-abiding service right away. And he worked there until 2008, so for a little more than 10 years. Since then, he has practiced law in Tabor. He specializes in administrative and construction law, land use. He has an active and productive practice. But at the same time, he has collaborated with law faculties on projects relating to professional ethics, human rights education. Since 2003, so for 20 years, he has been involved with the Pro Bono Alliance, an excellent Czech NGO. It's a nonprofit organization dedicated to legal education, increasing access to legal services, and promoting the professional ethics of lawyers. Vita regards the accessibility to legal aid for underprivileged and disadvantaged individuals as one of the greatest failings of the Czech legal system. I have had a great pleasure to get to work with Vita on a project several times, coming to visit Czech Republic, working with the Czech Union of Judges, working at Masaryk, making presentations at Charles University. So I've had a lot of pleasure to get to work with Vita over the years. Our second speaker will be Andrej Mernik. Andrej has a Juris Doctor from Comenius in Bratislava. He has worked since 1998 as an active, effective private lawyer in Bratislava. He has, in those times, he has not only worked for his own private practice of law, and very successfully, but he has been involved in the Via Juris board, which is a very successful and very powerful, high-quality Slovak NGO, with whom I have had the pleasure of working over the years on various projects. He was a nominee of the Ministry of Justice for the Slovak Republic membership on the boards, various boards for selection of judges. So he has participated on the boards for judicial selection processes. And since 2020, he has been a member of the Slovak Republic Judicial Council. Our third speaker will be Pavel Zilinchik. Pavel and I have worked together for many years. He co-founded and has led several NGOs specializing in public interest law, including Via Juris, the one with whom Andre has been actively involved for many years. Later than that, he worked on human rights protection and judicial reform issues through the U.S. Embassy in Bratislava as the human rights officer in the embassy, and there is where I met Pavel. He's also worked on human rights and judicial issues with both the Slovak and the Czech ombudsperson's office. And between 2016 and 2021, he served as a member of the Slovak Judicial Council. Currently, he participates in the selection of new judges through the judicial selection committees, and he acts as a lecturer at the Slovak Judicial Academy. So think of that, a private lawyer, not a judge, teaching judges courses in judicial ethics and ethical dilemmas. How about that? Pavel has studied law at Bratislava and also public policy at Princeton University in the US. So with that, I will turn it over to Vita, and I will keep track of the time and manage all of that, but the floor is yours, Vita.
Okay, thank you very much. Can you hear me?
Yes, perfect.
Okay, great. So thank you very much, Jim, for inviting me. Greetings to all of you, especially to my friends to Slovakia. We had a chance to meet 2 weeks ago, so we have a quite live connections now. Once in the history, I was in Georgia also. It was a great time, but it was in 2003, I think, so it's a quite long time. So it's a great pleasure for me to being here in this group. Jim just explained for which organizations I worked before. Just to explain about Environmental Law Service was a NGO. Is still NGO working in a different name now. I was an environmental lawyer, let's say, environmental activist lawyer. Some of my lawyer colleagues called us extremists. So from this, my active citizenship, let's say, maybe I started to be more active in fields in which usually lawyers are not so active. As Jim told you, I'm a private lawyer, advocate since 2008. But for the whole time, I'm still active in building capacities of let's say, NGO sector and in the human rights field. I'm quite reserved to call myself and my NGO, Pro Bono Alliance, as a NGO or me working on judicial reform. I never thought about it in this way before Jim asked me to take part in this session. We just do some activities focusing on lawyers and their capacities. We are not sure about the impacts of these activities, but you know, sometimes the response is quite positive, let's say. So I hope I can share with you something which could be useful. You will see. I'm prepared for questions and for discussions, of course. I prepared, I call it 5 principles, which are important in activities which I do, me and my NGO. And they are different than usual. When I hear about judicial or other reform, I think mainly people think about to prepare new legislation, new regulation, new rules, new bodies, new structures. and these things. My activities and activities of my NGO are focused more on people, on lawyers, because I personally believe that, not directly that rules are not important, but that more important are people working with the rules than the rules themselves. I don't know if it's clear what I'm talking about. In Czech, I will say something like that it's better to have a good lawyer working and applying the bad law than bad lawyer working with good law and good system. Good lawyer, label of good lawyer, I mean the lawyer who is taking seriously responsibilities of the profession, the specific profession in which the lawyer works, and is also aware about the role of the profession, this specific profession, in society, let's say. So that's why I'm more focused on lawyers than law, more lawyers than regulation. Especially in the human rights field, I think it's extremely important to make lawyers more sensitive. That's the key, I think, to raise awareness and sensitivity of lawyers on human rights failures and infringements and this. So make the lawyer feel the harm, understand the injustice, recognize unfair approach and these things. And how to go this way, this direction, how to do it to increase the sensitivity. One of these principles is like, I made a sentence, let lawyers to walk in the victim's shoes, to show lawyers, advocates, judges, prosecutors, other lawyers, to let them know how the situation is taken from the side of the victim, to understand how the victim is feeling about the injustice. From my experience, I'm like sure, or my understanding is that the human rights violations are mainly, not only, but mainly not done by people and institutions deliberately, with intention to harm. I think they are mainly, or on many occasions, made by or driven by prejudices, lack of information, lack of imagination, let's say, and mainly by different social experience. Of course, it's generalization. There are really bad people with really bad intentions, but generally, I believe that more information and higher sensitivity can help to reduce the number and seriousness of human rights violations. How to make lawyers to walk in these victims' shoes? To our different events, let's say gatherings, meetings, we try to invite also to involve victims, to let them speak, to let their voice to be heard directly by judges and lawyers and advocates. So that's one approach. And of course, we use real examples, case studies, and the real situations which can show and describe what are the harms and what is the situation of the victims. So first is to show the perspective of victims' perspective to the lawyers. The second principle or way how to make lawyers more sensitive is start from the roots. And I mean grassroots NGOs by this. So try to find NGOs. I don't mean lawyers, NGOs of lawyers associations. I mean really grassroots NGOs working with the victims, working with the people in the field, working with communities, to cooperate with them, to take experience from them, to extract stories from them and use them in the education and in the meetings and this. So cooperation with local NGOs, grassroots NGOs, people from the field, with community is the second pillar or principle in which we use in our work. The third one I call you can't teach an old dog new tricks. It's the same proverb is in the Czech language. What I mean, I don't know how old are you. If you are old dogs or young dogs, maybe it's more in the inside of our heads than counting on our age. But I believe that it's extremely important to work with law students mainly and young lawyers. I hope you are not offended now, but if you have a more experience, you can share the experience with the young lawyers and law students, because we really need to improve also number of lawyers involved in some public interest work, let's say, or in human rights protection, or in make a society better, saying generally. It's really important to communicate with them, to show them what is possible to do, to prepare options for them, possibilities to be involved, to take part in some activities. And it will help you in a longer time. Of course, this is not for, it's not activity for 1 month or for 1 year. It's a long-term perspective. But I'm sure that what you want to do, because it's dealing with reform, judicial reform, or other kind of reform of public services, let's say, it's of course long-term aim and a long way to go. So working with like young lawyers and law students is a third of my principles, let's say. And the fourth is make friends. I call it just to make friends. So it's other way to say, to call, usually we use in these conferences and meetings name or label networking, but making friends, it's better, I think. It means try to find a respectful individual in the system, respectful judge, advocate, law teacher, professor, I don't know, someone in the system, if there is, who is respected and at the same time open-minded. So find one, at least one, and he can or she can open the door for you to approach others in the system, or it will increase credibility of your activity, of your approach, or of things you want to share with the publicity. I mean, professional public. Of course, you have to offer your professional colleagues some useful content to prepare something which is useful for their daily work. Then you have better chance to find possibilities for cooperation. You can connect to events which are prepared by others. I don't mean like to hide and come there, but to find a way how to offer them that you can make some presentation on a topic which is important for them. And during this possibility, the opportunity, just show something what you want to show to them and offer them. Of course, you can make connections or connection with associations of advocates, judges, or other professionals. It's especially in our part of the world, of course, it's very important to choose the right friends. It's not good to make a friend with bad people. Even it can help you to be for a short time in a lights and to make some small progress. But because all we have is credibility, you can make a difference in a society if normal people will believe in what you do, and if they will believe that you do your activities in their interest, in a public interest, not in the interest of bad people. So please don't make connections and friendship with bad guys. But generally, make friends, make connections, and networks is a other principle. I've said 5 principles, but in fact I have 4 only. But the first principle is to raise sensitivity of lawyers, show them why it is important, how the victims feel about the situation. What we do, just a couple of examples of our activities. For more than 15 years, we organize human rights school for law students. This activity came to us from Slovakia, so thank you, Slovak brothers. But we continued, and we have a human rights school for law students every year. It's a 1 week intensive workshop session on different issues of human rights. So one type of activity. We organize workshops of methods of teaching for law teachers. So it was the activity useful for them, but we made quite good connections with law teachers, and because in my country, usually law teachers also have some private law practice, let's say. They are attorneys, advocates also. So we offered something useful to law teachers, and we make some network of people for the future cooperation. We organize usually roundtables or workshops in which we invite private lawyers, prosecutors, law students, judges together. So some interdisciplinarity is also important. And we organize pro bono clearinghouse. It means we are connecting need for legal help from NGOs and connect it with private law firms, lawyers, providing free of charge legal services. And we also organize discussion forums on professional ethics, something in which we cooperated with Jim. And we are involved in a pro bono Lawyer of the Year award ceremony. So we have a category of pro bono Lawyer of the Year. So it's one of the events organized by other entities, by Czech Bar Association in connection with some private lawyers. But we were able to put our agenda, piece of our agenda, promoting pro bono lawyering into this rather VIP activity. So these are some examples of what we do and organize for a longer time. So to just shortly wrap up of what I said, I'm convinced that it's important to work on increasing sensitivity of lawyers. And for this, it's good to show them victims' perspective, start from the roots, meaning NGOs, small NGOs, and working with community, working with law students and young lawyers for the longer perspective work, and making friends, meaning networking. So that's what I can share with you. I'm prepared to answer your questions. Thank you.
Thank you, Vita. Thank you very much. Does anyone have any brief question for Vita at this moment? We can come back to it if not. Okay, let me say just a very brief word about Vita's comments. Of course, I agree with all of your principles, Vita. They are brilliant, and it's interesting to me that you would say you didn't know you were engaged in judicial reform. In my judgment, one of the things you said is crucially important, and that is that rules matter. Of course they do. Systems matter. But the spirit of the legal professionals is what really matters at the end of the day. It is their commitment to public service, their commitment to understanding that their role as lawyers or judges is to serve the public, and especially judges, of course, because they work for the state. And so, to me, while at the same time we should be working on new systems, new structures, new rules, people like you need to be working, and I believe this is what I tried to do in my education work around the globe. People like you need to be working on the long-term change, which is building the spirit, building the kind of understanding of the young professionals, legal professionals, some of whom will be the judges in Czech Republic as time goes on, and building them to the point where they have this understanding inside them, right? They don't have to be motivated by a rule all the time. They have this understanding inside them that their job is to serve the public interest. And so for me, programs and projects like yours are implicitly working on judicial reform efforts that are long-term, that will play out over a long period of time. So thank you very much. Okay, Andre, can you share your screen, or do you want me to do it? Because I know you have you're muted, sorry.
Sorry, I was muted.
That's okay.
Can you hear me?
Yes, we can hear you great.
Okay. Jim, I think I can share.
You can share it, then you do it. That's
I'm
better.
going
Awesome.
to. I'm going to do it.
I will stop mine, and you can do yours.
Okay. Where is this? Share. Ah, yeah. Yeah. Okay.
I think you have the power to do it.
Okay.
There it is.
Here it is. Okay.
Okay.
Fine. Okay, maybe I will switch off the video because of the poor connection in order I can be heard.
Okay.
Okay. So once again, thank you very much for inviting me here. It's an honor. Jim, you described me as an expert. I don't feel as an expert, but certainly I feel that someone who can share my experience. As regards to all of you, the Czech Republic and to Georgia. Unfortunately, I haven't been to Georgia, but a lot of my friends visited Georgia, and everyone told me it's a wonderful country, so I ought to go there. So certainly I would like to go there. And now let's go to my modest contribution to this discussion. Okay, I think it's necessary to say a few words about the Judicial Council of the Slovak Republic, its position, composition, and powers. The Constitution defines the Judicial Council as a constitutional body of judicial legitimacy. These are the precise words, constitutional body of judicial legitimacy. This definition was introduced through a constitutional amendment recently in 2020 with the aim of settling the ongoing debate about its nature. However, this debate continues to this day, but this is another separate issue to discuss. So what does the concept of judicial legitimacy mean? And this concept is precisely reflected in the primary powers of the Judicial Council. And I put it there. Judicial Council proposes candidates for judges of general courts to the President of the Slovak Republic after examining their property conditions and the so-called prerequisites for judicial competence. So it's the fitness. Okay, sorry. Can you hear me?
Yes, it's
Okay.
fine, Andre. I think somebody just had their microphone active for just 1 second. It's okay.
Okay, so these prerequisites include assessing whether the judge possesses the necessary moral standards and integrity for the proper performance of their function. Then there is another very powerful power, proposes candidates to the president for the appointment of the chairman and vice chairman of the Supreme Court and the Supreme Administrative Court. So we effectively select judges for these positions. Then another powerful power, the Judicial Council decides on the assignment and transfer of judges to higher or different courts. Then we submit proposal to the government for candidates to act on behalf of the Slovak Republic in international judicial bodies. During the last session in September, we provided the government with 3 candidates for the European Court of Human Rights. This includes also the General Court of the European Union and the Court of Justice of the European Union. Then Judicial Council monitors judges' assets, property, and ensures that the so-called prerequisites for judicial competence are fulfilled. Thus, the Judicial Council has limited authority to initiate disciplinary proceedings against a judge. Then the Judicial Council elects associate judges, lay judges to the disciplinary panels of the Supreme Administrative Court. So this is another powerful power. We selected all these lay judges at the beginning of 2022, so last year was very fruitful. And then Judicial Council elects members to the selection commissions responsible for choosing judges. The process of selecting judges in Slovakia is quite complex and essentially consists of two phases: the initial selection before the selection commission, and the second is evaluation by the Judicial Council. The third phase, the appointment by the president, is more or less a formality. And finally, Judicial Council elaborates with the bodies of judicial self-government to set the principles of judicial ethics. You can see on the first picture, this is the building where the session of the Judicial Council takes place, and this is the table. And you can see on the left side all members of the Judicial Council nominated by three powers I will describe. And on the right side, these are the members of the Judicial Council who are the judges. This is quite recent picture, took 1 month ago. So the Judicial Council consists of 18 members. 9 members are elected by judges, 3 members by the National Council of the Slovak Republic, 3 members are appointed by the President of the Slovak Republic, and 3 members are appointed by the government of the Slovak Republic. I have to add that only individuals with integrity, a university degree in law, and at least 15 years of professional experience are eligible for such appointments. These persons on the left side, the members appointed by the parliament, the president, the government, cannot be judges themselves. This is another outcome of the recent constitutional reform. So therefore, the composition of the Judicial Council with members appointed or elected by various branches of government also serves as a significant legitimizing element. This is a very nice definition of the Judicial Council. It's a quotation from one of the decisions of the Constitutional Court of the Slovak Republic. I think it aspires for the very best of the Judicial Council. You can read it by yourselves, but in essence, it says that in the Judicial Council, there should be persons, high-qualified persons, high-qualified lawyers who cares about justice and who are willing to participate in the dialogue. And the Judicial Council, if composed of non-judges as well, is a privileged forum, a platform through which discussions about justice take place, and judges and the entire justice system receive feedback on their performance. This is what I would like to strengthen. This is very important, and I will come to this word feedback several times in my contribution. So now that I have described the powers and the composition of the Judicial Council and the mission of the Judicial Council, what is the role of a private lawyer thereon? One technical note: if I say a private lawyer, or an advocate, I will use these terms as synonyms. They mean the same. So given that only a lawyer with 15 years of practice can serve on the Judicial Council, it is understandable that members of the Judicial Council, not from the judiciary, so non-judges, will also be selected from among advocates. First of all, let me explain the normative environment, if any, in which an advocate acts within the Judicial Council. The only regulatory boundaries are established by the Constitution and the Act on the Judicial Council. Neither the Advocacy Act nor the professional regulations for lawyers regulate the participation of advocates in the public oversight of the judiciary in any way. Needless to say, an advocate like myself is under no duty to follow any instructions from the bar, nor is he or she, like myself, obliged to promote any interest of advocates or the bar as such. The law does not distinguish between a member of the Judicial Council who is a judge and who is not a judge. Everyone participates equally in the activities of the Judicial Council. So, what experiences and knowledge can a lawyer bring to the Judicial Council, and how can these be effectively applied in some of the roles and responsibilities of the Judicial Council, as I mentioned above? What I would like to highlight is the participation in discussions about the judiciary in general. This is about this dialogue. This is about the feedback. So I would like to highlight the role of the Judicial Council, where justice is supposed to receive feedback. Who else but a lawyer can convey this best? After all, we advocates represent the primary consumer of this state service, namely the parties in the proceedings whose rights and obligations are decided upon, or the accused in criminal proceedings. A lawyer has repeated and diverse experience in dealing with court decisions, conducting proceedings, and dealing with judges in courtrooms. All of this can be conveyed during discussions in the Judicial Council. Let me provide one example. This is example from my experience. Our Judicial Council was deciding on the transfer of a judge to a higher level court, from the district court to a county regional court. As I said earlier, part of this process involves overseeing the prerequisites of judges, the fitness to be on the higher court. During the interview with the selection committee, the judge herself admitted that she sometimes raises her voice in the courtroom. One member of the Judicial Council, an academic, asked her if she was working on correcting this behavior. In the discussion, another member of the Judicial Council, a judge, a judge with a very long practice, criticized the member academic, saying that since she had never been a judge and had never represented a party before the court, she could not understand that sometimes it is necessary to restore order in the courtroom and even raise one's voice. In discussion, I shared my own experience. And this is my experience. Some judges shout without reason and behave impolitely in Slovakia. None of the judges, members of the Judicial Council, responded to my contribution. My input could not be dismissed by saying that I lack experience in conducting proceedings. I spoke as a lawyer, as an advocate. You might think this is an anecdote, but an important one. What I didn't mention is the fact that the Judicial Council is a very transparent body. There is a live broadcast from every session of the Judicial Council. So you can imagine it's streamed lively, and the session is recorded, so everyone can listen to it even later. So this was an important discussion. A discussion took place in the Judicial Council that was heard by judges and the public about an issue that is rarely discussed. The Judicial Council here at that time served as an appropriate platform, and the lawyer's experience was valuable and balanced the judge's perspective. And one more note, when the Judicial Council selected lay judges for disciplinary senates in January 2022, one of the successful candidates, so now a layman, an associate judge who served in the disciplinary senate, who is an advocate, answer the question what she considers one of the biggest problems in the justice system with. And she said, frequent rude and discourteous behavior by judges. Clients are very sensitive to this, and it erodes the trust and confidence in the justice system. So through the Judicial Council, the justice judiciary got a feedback. And it was just one example of the very important role in which an advocate can play a role in the Judicial Council. Another important area is the participation in decisions regarding personal matters. An advocate can play a positive role in decisions regarding personal matters, especially in the process of selecting judges, proposing individuals to serve on the selection committees for judicial positions, I mentioned, proposing individuals to serve as associate judges in disciplinary senates, what I mentioned as well, or nominations for judicial positions in international judicial institutions. Many judges, and this applies to judges in the Slovak Judicial Council as well, tend to prefer individuals who have worked in the courts as judicial clerks or assistants when selecting judges. In the case of other positions, they tend to favor judges. Even in the case of judges who are open to the idea of transitioning from one legal profession to another, their knowledge of the non-judicial environment is limited due to their professional background, and they are often unaware of many excellent lawyers who could serve as members of selection committees or associate judges in the disciplinary senates. I don't need to emphasize that it's precisely individuals from outside the judicial environment who bring an outsider's perspective to the judicial system and balance the corporatist views among judges. I have successfully proposed 2 associate judges from the ranks of advocates for disciplinary senates, and so far they have provided very solid service, I must say. I have also proposed 2 candidates for the European Court of Human Rights from outside of the judicial environment. Finally, another and the third area where the role of advocate might be important is the assessment of the prerequisites of candidates and judges and examination of their property conditions. The Judicial Council, in its assessment of the prerequisites of candidates and judges, as well as in the examination of their property conditions, evaluates various situations in which candidates for judicial positions as former entrepreneurs or employers find themselves. Similarly, many judges' spouses hold such positions. Such knowledge and experience can streamline the work of the review committees established by the Judicial Council to assess property conditions properly. Advocates can draw attention to important facts and conversely mitigate some unrealistic requirements. And here is another example. During the last session, the Judicial Council was evaluating a candidate for the position of judge who had served as a director of limited liability company for nearly 10 years. However, she did not mention this in her CV, in her resume. It was discovered that this company in which she was registered as the director had tax debts. When questioned by the control committee about why she didn't include this in her resume, she replied that she had never actually managed the company. She also wrote this in her affidavit, presumably thinking that distancing herself from the company would help her. She also stated that the tax debt was a result of fraudulent actions by an external accountant. Some members of the judicial councils, mainly the judges, saw the wrong choice of an external accounting firm and the fact it did not perform its duties properly as a failure and therefore a defect in moral standards or integrity. In my opinion, this is an extremely stringent requirement for an entrepreneur, as the business soundness of the decision is judged retrospectively. I explained the above from my own experience as an entrepreneur and as an employer, as well as with the reference to doctrinal views. So I somehow influenced the discussion. And this discussion was influenced by a private lawyer or an advocate. Finally, I did not vote in favor of this candidate because she provided false information, obviously, in the affidavit, and also questioned her own expertise. So she didn't seem fit for this position. So finally, she didn't become a judge because she didn't gain the majority of votes in the Judicial Council. And in conclusion, a few warnings. An advocate's membership in the Judicial Council is tricky. If an advocate wants to carry out the role properly, they cannot avoid making decisions that may antagonize certain judges or other persons in the judiciary. In several cases, I voted against transferring a judge to a higher or different court because I believed that the judge in question was unsuitable, either morally or professionally. I know that this has been met with a negative reaction, sometimes fierce. I believe that in some cases, which I will likely represent, I will have to raise objections about bias or at least point out that a particular judge against whom I voted in the Judicial Council may not appear impartial in relation to me. However, such a risk should not influence the autonomous decision-making of a member of the Judicial Council who is an advocate or a private lawyer. It can obviously be avoided by the advocate participating less in proceedings, criminal proceedings, civil proceedings, during their tenure in the Judicial Council. But this would, on the other hand, mean losing contact with the judiciary, which is precisely what is needed. And one temptation: an advocate in the Judicial Council is strongly tempted to serve not only the entire society, but also themselves. They may want to use the Judicial Council as a platform for networking and currying favor with judges. Unfortunately, I have observed that some advocates who were members of the Judicial Council, when making personal decisions, had praised a certain judge with adoration, starting how excellent the judge was. I think this is not good. And this was my final remark. Thank you very much for your attention.
Okay, thank you very much, Andre. Those are very interesting remarks about the blending of roles that a private advocate has to consider and, contemplate as they play their activity within the Judicial Council. I think we all learned something from that. Does anyone have a short question for Andre right now? And if not, then we will move on to Pavel. Okay, Pavel, I think the floor is yours. Thank you, Andre. We will have questions later, I'm sure. Pavel, the floor is yours. Pavel is somebody that I sometimes embarrass by calling a Renaissance reformer because he has served so many different roles as someone reforming public policy, but especially the judiciary in Slovakia. So I'll turn it over to you.
Thank you. Thank you very much, Jim, and the greetings to both Czech Republic and to my friends in Georgia. I was in Georgia. I think it was year 1989 or 88. It was one of the most remarkable trips in my life. And if we have time, we can discuss why. But for now, I will focus on the subject of this presentation, of this session, and I will divide my intervention into three parts. I will speak briefly about the role of attorneys and bar associations in judicial reform. Then I will touch upon the role of other private lawyers, be it NGO lawyers or an embassy employee or ombudsman employee in judicial reform. And then I have some questions I would like to discuss, because I want to use this opportunity also for myself. And I have some critical questions which I couldn't find an answer to. So I would really like to raise these and hear your opinions about them. Let me start with one cartoon. The cartoon describes many different levels of how lawyers are being perceived, how do they or don't they fulfill the role the society expects from them. And I will show you this cartoon from one of the most famous cartoonists in Slovakia. His name is Shuti, and the cartoon goes like this. Can you see it, please? Is it possible to see the picture? Excellent. So, law graduate, the man on the left side, is receiving the Doctor of Law title from the legal professor of the law faculty, who obviously, as almost all legal professors in Slovakia, also has his own private attorney's office, because that's very common here. And the professor says, "You have become a doctor of law, and there is no better qualification for plundering this country." So it tells you how the society perceives lawyers, be it attorneys, be it judges, whoever. It was super interesting for me. I saw this cartoon. I said, I'm a lawyer. I have to admit, people may think this way about lawyers, and I didn't feel offended at all. However, the Slovak Bar Association issued a press release condemning this cartoon in such harsh words, comparing it to the totalitarian language, aiming at a certain group of citizens, and on and on and on. Very, very harsh statements. And I was quite shocked, because in Slovakia, before this cartoon was published, there were many scandals, there were many corruption cases involving attorneys, involving judges, but the Bar Association has never issued such a strict statement condemning corruption, condemning illegal activities, or shady or unethical behavior of attorneys, and so on. We had this period of darkness in rule of law between 2006 and 2012, when judiciary was managed by people who didn't deserve to be judges, not to mention to rule the judiciary as such. These people were prosecuting the good ones and promoting the worst judges to the highest positions, but the Bar Association was quiet. So it was really interesting to me to see how sensitive it was when it comes to its own honor, reputation, and interests. So I wanted to start with this to discuss several symptoms, and then maybe perhaps also some ways out from the situation when we speak about the role of bar associations and lawyers in judicial reform. Let me give you one case study. Around 2005, there was a case which really shaken the Slovak discourse regarding attorneys and bar. We had a case of corruption when one attorney attempted to bribe another attorney. So there was corruption between two attorneys. The first one offered significant amount of money to the second attorney if she convinces her client to change his testimony in the criminal proceedings in favor of the first attorney's client. So attorney A offering money, asking attorney B to convince the client of her, so he changes the testimony. so the client of the first attorney benefits. It was a shocking situation for the second attorney, and she evaluated this situation in a way which was shocking for the Bar Association, because she started to cooperate with the police, and she acted as a police agent when uncovering this all corruption scheme. So she was equipped with a recording equipment, and she recorded the discussion with the bribing attorney, and so on and so on. Long story short, the Bar Association decided that such behavior of attorney B, the one who cooperated with police and wanted to uncover the corruption, the Bar Association decided that such behavior is not consistent, not compliant with the obligations of the attorney, and kicked her out from the Bar Association. So she was disbarred, basically. It was a shock because, you know, for a country in transition like Slovakia was and still is, it was not comprehensible. How can a Bar Association kick out an attorney who fights corruption within the Bar Association? Now, the situation, of course, from the legal point of view, is more complex. It is a legitimate question whether and if, to what extent, the attorney can cooperate with law enforcement agencies in the position of the agent, because there is wiretapping involved, and it is difficult to protect the client's attorney privilege if somebody's phone is wiretapped, and so on. This is a legitimate discussion which needs to be taken seriously. However, the harsh punishment against attorney B and the very soft approach towards the other attorneys, towards other perpetrators of corruption, towards other accused or being involved in various corruption activities, it was really a shocking discussion for us from outside to observe. And I have to say, and this is the first takeaway from my presentation, I really enjoyed the freedom to be able to discuss the point of view from the position of somebody who is not obliged to follow any rules, be it Bar Association rules or judges' code of conduct or whatever. I had the great freedom to discuss this case and discuss my opinions. And actually, I was approached by one of the main TV station to confront the president of the Bar Association because, and that was something very interesting for me, because the reporter, the journalist, did not find another attorney who would be able to speak out about the case. I am not saying nobody wanted to speak, but he approached me. I was not member of the bar, although I was attorney trainee some years before. For many years, I have this training, but I never choose the path of an attorney. I choose different professional career. So from the outsider's perspective, I had the freedom to speak out. And I think that the discussion was very important. At the end, the Supreme Court overruled the Bar Association's verdict and canceled the disbarment. So she still is an attorney, although the court also said she shouldn't act in the position of police agent. So this gives you some flavor of the complexity of the situation. The Bar Association, on one hand, was quite soft when it comes to various forms of corruption. The statements were always, we need to keep the presumption of innocence seriously. We cannot comment on pending criminal procedures of our members and so on. But once the situation is looked at from another perspective, like the attorney B, or the cartoonist, the Bar Association is actually able to formulate statements very, very clearly. So this was one point I wanted to raise, and the main takeaway is freedom of somebody being outside. Now, I will switch to my second experience, which was the Judicial Council one. And the takeaway is still the same. I really enjoyed the freedom of somebody who has not the obligation of loyalty to other judges, who I was in position that I didn't, expect anything from the judges who were being discussed for promotion or discipline. I didn't expect anything from the presidents of the court, the president of the Judicial Council, and so on. So again, huge amount of freedom was the big advantage, although this position also have many disadvantages, and I will mention them at the end. But for now, I will at least briefly mention when Andrei was talking about his experience in the Judicial Council, I remember that I read some good soft law principles about the non-judicial members in the Judicial Council, and some of them are not very frequently discussed. So I will at least briefly offer some of the principles which are formulated in the European Network of Judicial Councils standards, number 6, non-judicial members in the Council. And the principle is this: effective participation by non-judicial members in the work of judicial councils assists in avoiding either actual or perceived self-interest, self-protection, or self-referencing within the judiciary, as well as it helps to give the judiciary greater legitimacy and reinforcing of the role of judiciary as guardian and defender of the basic rights of each citizen. So perceived self-interest, self-protection, or self-referencing within judiciary can be addressed via people like me, people from outside. Second point, and that's the last one, non-judicial members can hold up a mirror to the judiciary, showing a different side to certain issues. Non-judicial members can look at the issue from a broader perspective. They are not constrained by professional judicial habits and stereotypes. This is, again, very important. Openly, that these documents, author is the Network of Councils of Judiciary, openly speaks about the habits or stereotypes in the judiciary. They can represent the interests and views of the society and become a connecting bridge between judges and society. So these are the formulations which I, from time to time, had to read at the session of the Judicial Council, because sometimes I felt as somebody who is not welcome. I am not a judge. I was never a judge. So the judges in the council were suspicious. What are my interests? Why am I there? And at the end, what do I know about judiciary? So at one point, I had to read these principles and legitimize my participation. And actually, it helped. And this is my second takeaway. Vita said a very important sentence: make friends, make connections, be in touch, be in contact with people. I would say build coalitions. Build coalitions. Don't perceive the body or the conflict or the issue as binary. These are them, we are here, and these are the two entities fighting. Actually, they are usually not a very comprehensive entity. People are always on scale, and some, even from the opposite camp, from the opposite side, or maybe I am not expert on the judiciary in Georgia, but in Slovakia, I can even say from the opposite clan, some of them over time may listen to what we are saying. And I have experienced this with my own eyes over the 5 years in the Judicial Council. At the beginning, I was somebody like enemy of the state. He is not one of us. I felt this at every single session of the council. But I kept explaining, I sticked to fairness. I tried to explain every point as the best way I could. And at the end, even from the opposite side or opposite clan, people started to side with me, which was quite unbelievable. But I can confirm that this is possible. So number 3, this was the Judicial Council experience. Number 3 are my questions. I would like to ask you all if we expect from the Bar Association that it will somehow promote judicial reform, protect rule of law. Is it a fair expectation? Because the primary goal of the Bar Association is to represent and pursue the interests of the client. If the client is criminal, which very often is, the Bar Association enables its members to represent the interests of this person. Now, if we expect from the bar that it will actually fight corruption or promote ethics in the legal professions, is it a realistic expectation? My answer is that it is, because these principles should be somehow balanced. But I would like to hear from you what you think. Maybe we think, maybe our expectations are too high, or they should be calibrated, evaluated somehow, and making them more realistic. Because if we perceive a bar as somebody who is the rule of law agent in a country, I think first we are far from there, at least in Slovakia, and secondly, I am not sure if it is even possible. And my second question also relates to bar associations. I don't know how it is in other countries. I know only about Czech Republic and Slovakia. But in Slovakia, Bar Association is, without any doubt, one of the strongest lobby groups in the country when it comes to legislative process. There are hunters. Hunters are another very powerful lobby because many MPs are hunters. They like to hunt animals. Bar Association is also very effective lobbies. And one aspect of this is that I was quite surprised when I learned that members of parliament are prohibited to continue with their entrepreneurship or business activities when they are in the parliament, when they are members of the parliament. But attorneys, they can continue their business. Even if they are MPs, they also are active attorneys. This is an academic question whether it is okay or not. I know that in Czech Republic, some attorneys suspended their license while sitting in the parliament. Others decided they will be keeping their business alive during their membership in the parliament. But in Slovakia, it became absurd because some of the MPs are some of the most powerful people in their countries. So they are high-level politicians. At the same time, they are attorneys and they represent other MPs in their, for example, criminal or corruption cases. So they have access to the files, which is very, restricted when it comes to pending criminal proceedings. Not everyone can review the file at any stage, but the attorney can. And we see that these attorneys now are in some kind of vicious circle, that they are attorneys receiving sensitive information from the file, then using them in the political fight. And I was quite curious whether this is normal or it's some kind of mistake in our system. But I wanted to share this question with you because, for example, we had elections 2 weeks ago, and the prime minister, the justice minister, and the defense minister, the three very powerful people in the future government are all high-level politicians from one and the same party, active attorneys representing corruption cases here and there. And I see it as some kind of subject for future discussion. So to conclude, whenever you try to influence judicial reform or rule of law reform, in our countries, it seems like a never-ending process. It seems like it will never be done. And yes, it is difficult. The rule of law reform is one of the most difficult reforms for transition countries. But I see that building coalitions, sticking to principle and fairness in one's action, transparency, this all helps to cultivating the environment. It helps to find, even in the other clan, people who actually are able to think and are able to take a proper or right position in a certain conflicting situation. This is all for now, and I look forward for your question if you have some. Thank you.
Thank you, Pavel. So we've been invited by Pavel to engage a couple of specific questions for him. So I think we should stick with those at the first part, if possible. If we can stick with Pavel's questions of us at the beginning, and then we will broaden to anything anybody wants to ask any of our panelists beyond that. I see Kaka's hand is up.
Okay, can you hear me?
Yes.
Okay, hello everybody. Thank you for this very interesting presentations. We have heard a lot about Slovakia, but every time we are surprised to discover some interesting stories, some new developments, because there is quite a lot of similarity between Slovakia and Georgia. When it comes to this, I guess, the size of the population, the culture, the history, the legal traditions, there's some similarities, I guess. And we also had this problem of we still have this problem, the big problem of corporatism in the judiciary. So I would like to raise some questions and also make some points. My question, I will start with the questions actually. And the question number one will be the role of the legal profession in Slovakia and also in the USA in interviewing the judges. Interviewing judicial candidates, and also providing assessment or information about judges. Well, the point is that the lawyers, they know the judges better than I do. Because they see them every day in the courtrooms, and I study their biography. I'm an academic person. I don't practice the law. So the lawyers, they are much familiar with the judges than I am, and I'm an NGO representative. So the question is whether the lawyers actively use that information in the judicial career, in making decisions about judicial career. For example, selecting a judge, promoting a judge, and promoting a judge, and so on and so on. Whether they actually actively provide the feedback in judicial appointments. The question is whether the lawyers actively provide feedback in judicial appointment. There are some of the people who do not deserve to be judges, and there are some people who deserve to be high-level judges, and whether the lawyers, they are actually involved in the process. The second question would be, in Slovakia particularly, I'm interested, if the lawyers, like prominent lawyers, they want to become judges, and they do become judges. The question is, do prominent lawyers who are who have a great income, also high reputation in the public. Do they want to become judges, and do they become judges? In Georgia, some of them, they wanted to become judges, but they could not because they were disqualified by Judiciary Council. And after that, we don't have lawyers participating so much in a judicial selection process as candidates. I mean, I would just to name as an example, in 2019, there was an open competition for Supreme Court vacancy here in Georgia, Supreme Court vacancies here in Georgia, and approximately 140 candidates participated. And many of them, they were lawyers. But do you know how many lawyers they picked up as a Supreme Court judge? None. None of the lawyers were picked up as a Supreme Court. They were not selected. Maybe there is only one exception, but I do not consider this guy to be a lawyer because previously he was a clerk in the Supreme Court. So I do not consider him to be a lawyer in a classic sense. So out of the approximately 15 or some candidates, none of them were the active lawyers. And even now, in today's Supreme Court, there are 27 judges in Georgian Supreme Court, and none of them have been lawyers previously. I'm talking about the immediate previous career. I'm not talking about the career 10 or 20 years ago. 10 or 20 years ago, they may have been lawyers, but it's not. That's not the case. That's not the point. So that was my second question: whether the lawyers want to become judges and whether they do become judges. And my third question would be about the policy of the Bar Association in the reform of the judiciary. I think Pavel has mentioned that the Bar Association has not been very active. The Bar Association has not been very active in disclosing judicial corruption or advocating against judicial corruption or something like that. In Georgia, we had two scenarios. Before 2018 or before 2019, the Bar Association was very active in protesting judicial corruption. They were even out. They went out in the street with the banners, with the protest demonstration, everything. After 2019, the things have changed. With the new leadership, the things have changed. The Bar Association, he's not making any statements, I would say, he's not making any strong or harsh statements about developments in the judiciary. And I will make just one example. Just about a year ago, 4 judges have been sanctioned by the U.S. Department of Justice for the corruption. So they are sanctioned. They're sanctioned by the U.S. Department of Justice for the corruption. And there was a initiative in the parliament to create an investigative committee, an investigative commission in the parliament. And this was a very, very, very hot topic. And the Bar Association did not make any single statement, not in favor, not against. They did not say, yes, we are in favor of creating investigative commission. And they didn't say, yes, we are not, no, we are not in favor. They didn't say anything. And this was a very big scandal here in Georgia. It continues to be a scandal because we do have judges who are sanctioned by the United States for the involvement in the corruption. So that was my third question. What is the policy of the Bar Association? Are they just cooperating with the judicial leadership? Are they opposing judicial leadership? Are they making Are they making statements about judicial reform? That's my third question. Thank you.
Okay, thank you, Kaka. There's a lot there in terms of questions, but any of the three of you have a comment from the perspective of Czech Republic or Slovak Republic?
Maybe if I can start, Jim, because there are many questions, 3, but long, and I think they deserve quite a long explanation. And I think Pavel Zilinčík might add few comments. So I will start with the second question regarding the aspiration of the lawyers to become judges, mainly of the Supreme Court in Slovakia. One of the several things I am proud of, and I believe Pavel is also proud of, because at the time we were both together at the Judicial Council, was the foundation of the new Supreme Administrative Court in Slovakia. We copied to a certain way the Czech model, so good Czech inspiration. And fortunately, our reform was such that we managed to avoid the situation that all judges from the Supreme Court, from the administrative branch, would be transferred automatically by default to the Supreme Administrative Court. Instead of this mechanism, the Judicial Council acted as the big selection committee. And we managed to put into the position, because they deserve it, these candidates, few advocates. But to your question, whether many advocates, private lawyers wanted to be the judges of the Supreme Administrative Court, I can say no. Many good and outstanding lawyers. I asked at that time some of the lawyers who I admired, who I considered to be perfect lawyers, if they will to be judges of the Supreme Administrative Court. And the answer was no, because they earn 3 times, 4 times much more than the salary of the administrative court. So this is to your second question. So I think still the best lawyers are not, for the best lawyers, this is not attractive occupation. And on the other hand, there are some lawyers who want to be the judges of the Supreme Court, but maybe Pavel will add few comments on this. But the way how we select the judges from non-judiciary area for the positions of the higher courts and the Supreme Court of Slovakia is such that they are not able to pass the written part of exams. So this is a very huge obstacle. And I know several very good academics. Actually, there is one guy who teaches financial and tax law at Comenius, who is an excellent expert on tax and finance law, but he was not able to write the judgment. So there are obstacles of such character. To your first question, just briefly, and I think what I said was reflected by Pavel Žilinčík as well. There is a huge paradox. An advocate, as I said, and Pavel, and you mentioned it as well, advocate has a huge experience with courtrooms, proceedings, and judges. On the other hand, Pavel talked about this. There is maybe a fear to make enemies among judges and among some colleagues from the Bar Association. So some of these, and most of them, the lawyers from the bar, the Slovak bar, are afraid to speak out and speak freely. So I mentioned that at the end, that even for me, I can tell you, I think I made a lot of enemies among the judges, and maybe more enemies than the friends. So this is, on the other hand, the disadvantage. And the lawyers from other areas, like academics or lawyers from NGO, like Pavel Žilinčík, have certain advantage. They do not have any fear. But to your question, whether these lawyers participate in the selection committees and in the selection process, yes, I am a big proponent of this. They have to be there, but they have to act freely and with no fear to make even enemies. But to your question, whether they can use certain information they know about the judges. I think it doesn't work like this. It's not that particular information I know about a certain judge in courtroom from 10 years ago, but I think more valuable is the information about the environment, about the process, etc. You see, so these people do not, the lawyers and the advocates do not take advantage of what happened sometimes ago, their personal knowledge, but they utilize the information about the judiciary system as such. And maybe, Pavel, if you want to complete my comments and reflections, I would be very grateful.
It is a very complex issue. I will try to divide it between two aspects. One was the Supreme Administrative Court, which Andrei mentioned. Yes, it is true. Many brilliant attorneys did want to compete for those positions, but some did, and some became judges of the Supreme Administrative Court. So there is no a simple answer to the question whether they want and do become judges. Some do. The chance is there, and the process of selection consists of several steps. As Andrei mentioned, the first job in the general courts, not the Supreme one, the general courts, is the selection commission. And yes, bar association members, lawyers like me, are members of these. Even if I am not a member of the Judicial Council, I still participate in the selections as a non-judge, as the soft document from European Network of Judicial Council said, I still can provide the mirror to the system from outside. And I do it with a great pleasure, because that's the point where you see results. You have candidates, some of them are brilliant, some of them are not that brilliant, and some of them are horrifying. And we experienced here in Slovakia that the third group was super successful during some years in the past, while the best ones weren't selected. So for me to see that the good ones are making it is a great satisfaction. I think that's enough because we don't have much time, and I would like to ask Vítě if he has anything to contribute, although the Czech Republic doesn't have the Judicial Council. So what can Vítě contribute?
Okay, the question is if it's a good thing to have a Judicial Council or not.
No. Okay.
It's possible to live without Judicial Council. Even if me personally, I'm in favor to establish some kind of Judicial Council, and I think the mirror is very important, and we don't have it in my country. But we have something which I very briefly can talk about. Now we have about, in 2 years, we will have to find about 7 judges of Constitutional Court, which is a very open selecting process. The competence is divided between President and the Senate. In this respect, President formed some kind of consulting panel, which should help him to find good candidates, nominees for the Constitutional Court. And through the panel, he asked Bar Association, prosecutor, not association, but somebody of prosecutors, universities and other institutions, to give him some advice to help him to find the right nominees. But for example, Czech Bar Association took it as okay, we will nominate our members as a good potential constitutional judges, which was not a good idea, because Bar Association choose these people from inside the bar association itself, so people from the system. And till now, none of these advocates were took to the selecting process by the president. So it depends how do you take how seriously and what is the idea behind of the selecting process. And what I want to add, I think sometimes the members of the bar association, private lawyers in a judicial council or institution like this can afraid of conflict of interest, let's say, or conflict of loyalty. Because as Paolo said, I don't think bar association has a conflict with interest of clients, because bar association doesn't represent clients. But the private lawyers as a member of council could. And of course, I don't have a problem to make enemies among the judges. I have no problem with this personally, but I would be afraid of my clients, of interests of my clients. And I'm not sure if it's easy responses. Now your role is a member of the Judicial Council, so forget about your clients. So it could be, I think, tricky, but we don't have a council, so I'm okay.
Okay, thank you. Maybe some of you know that along with three Slovak academics and we wrote an article maybe 5 years ago that warned that some parts of the European system, including the Judicial Council, that has been encouraged and even required of members, CEE members, may actually lead to corrupt circumstances, may actually lead to too much power within the judiciary that doesn't have the sufficient accountability. So we've actually published an article about that. I saw Irakli's hand up.
I briefly answer one of the questions from Pavel. It was, I guess it was 3 questions, but just to economize some time, I just answered one question. Can be lawyer in Georgia be concealed agent of police or some other state agencies? Actually, when I was chair of the disciplinary commission of the Georgian Bar Association, we even suspended one lawyer for being a concealed agent of a prosecutor's office. We did not rule out to be agent per se, unless it is not on the contractual basis, not subject to any remuneration. We were influenced by Chicago case in US when lawyers were used to arrest and prosecute one corrupt judge. But in the Chicago case, the client was faked one. In a Georgian case, client was real. Lawyer, defense attorney was in breach of principle of independence and priority of client's interest when he acted as per instructions of prosecutor's office as concealed agent to transfer bribe, black money to judge. As a result, the judge was arrested as well, but the lawyer was suspended for 18 months. So yes and no, lawyers can be used as agent, provided that no client's attorney, no duties towards client which prevails is breached. So this is short answer to this question. Because it is also the role of it is related to our topic, the role of private lawyers in judicial reforms. So as Vitslav mentioned, it has corporate, institutional dimension and also private dimension, and we are dealing also in private dimension when lawyer can assist to prosecute, get rid to corrupt judges from judiciary. Thank you.
Thank you, Irakli. I had one brief comment on one of Pavel's questions that I think hasn't really been addressed yet. And in my experience in working with bar associations in many, many countries, this is not just the US, but it's many, many countries in CEE, but also even Southeast Asia, I find that bar associations have schizophrenia. They have split personality, right, in a psychiatric sense. So partly they are a public entity, right? They are created, by some law. In Europe, they are created by the law and advocates usually. In the US, they are created by a state Supreme Court and given powers of the state. So on one hand, they have this body of powers of the state to enforce the rules of ethics against lawyers. And in that part of their split personality, yes, they definitely should care and do everything they can to make justice better. They should be working to reform law. They should be working to reform the quality of justice in the country. No question. They are a public body that does this. But they have another personality, right? The other personality, I don't think, as Pavel said, they are worried about clients so much as they are like a trade association for lawyers, right? They operate almost like a labor union or trade association for lawyers themselves. So their split loyalty is between this public interest because of their status as a state authorized agency to do certain public things, but they also seem to act in the best interest of lawyers. And some of them, I will say the Slovak one that I had only a little bit of interaction with, I think and when I did it, at least, it was so completely on the side of the personality of taking care of themselves, right? Watching out for other lawyers, and not so much on performing the state functions. But in other places, it's more even, and it's hard to know what personality the bar association will take. Obviously, I think people in this group, and myself included, would wish that their public obligations would prevail, that their public obligations would win the day whenever there is some tension between public obligations and their sort of status as a trade union for lawyers. But I have found that they always, everywhere, seem to have this split personality, this schizophrenia in their actions. Okay, we still have a few more minutes. Anybody else have a question for any of our panelists? Anybody have another question?
Sorry, Jim, just a quick remark. What you said, is it possible?
Okay, Kaka, and then Irakli, pretty quick.
It's just a quick remark. What you said, as a humoristic note, I would ask the question: is it true that the lawyers can make more money if the laws are ambiguous? I mean,
probably yes. I think it generates more controversy and conflict if laws are hard to interpret. Yeah, I think it probably contributes. I think I agree with you on that, Kaka.
Yeah, yes, but on the other hand, the legal profession in general of course, I mean, the legal profession in general is in the universities is taught. We are taught to contribute to the rule of law, to the human rights, to the justice, to the fairness, and so on and so on. In the universities, they don't teach us how to make money. They teach us that the rule of law is the most important, that the justice is most important. So I guess that these idealistic values, they come more from the universities, from education, from public, from the public expectations, and so on. They don't necessarily come from the corporation by itself. They come from
probably and they also come from programs like Vita, has tried to continue to run. I mean, yes, and we hope, we wish that the public value
I didn't want to end this discussion without mentioning some of these interesting things also here in Georgia. There was an idea of the bench bar in 2007, and I was one of the contributors of the bench bar in 2007. We created the bench bar in 2007. It operated for about 2 years. And now they resumed the bench bar approximately a year or 2 years ago. They resumed the bench bar, and they are talking, and the judges and lawyers, they get together. They are talking about juvenile justice, domestic violence, the case law, and so on. So I think this is a positive development, which I just wanted to say.
Good.
Thank you.
Yes, it can be a good thing. Irakli. You're muted. You're muted, Irakli.
Two short questions. One is for to Vítězslav, and second is to Andre. I start a question to Andre. Is in Slovak, as we heard, it's possible for lawyers, practicing attorneys, to be members of Judicial Council. In Georgia, it's not possible. An attorney has to suspend its activity. How the conflict of interest is regulated in fact, in practice and on paper, because sometimes practice and paper rules are not identical. So this is one question, and the second question is to Vítězslav. You mentioned that it's important to make friends, and even making friends with bad people who are in opposite clan or side. And Pavel also just transformed it that it's important to make coalitions with people. Yeah, how it's what are tricks or your experience how to make friends with bad people and to force them to make good things, so to be on the side of reforms and actually making good people out of bad people, which is as a result. We are not talking about the general, just for this idea of reform, specific reform, or some other positive objective. So I'm done. Thank you.
This is a very good question. And it's indeed, like you said, we have a special constitutional act. This is not the constitution itself, but the constitutional act which tries to regulate these conflicts of interest. And you are right that in general, almost all governmental positions and people who serve as governmental agents are not allowed to perform business activity. There is one of the examples is the position of the member of the Judicial Council, and I think it's partly because since 2021 it was unpaid job, so it was performed voluntarily. Pavel Žilinčík can talk about it a lot. It has slightly changed, but the remuneration is not very high. That's why the law system preserved this, that I can still perform business and advocacy practice. And to your question, there are conflicts of interest which are regulated by this law. For example, I am not allowed, I am forbidden to develop my business and to promote by promoting that I am a member of the Judicial Council. So I'm not allowed to say, look, go to me, dear clients, I'm perfectly networked with many judges. But this is too far. But even saying I'm a good lawyer because I'm a member of Judicial Council. So myself, I try to be very moderate to talk about this. I think that on my web is just mentioned that I'm a member of the Judicial Council, but I don't promote this further because this is really dangerous. And of course, what Vita said on the other side, and he's absolutely right, and it was my question. Since I am in Judicial Council, I decreased the number of my representations before the courts because I feel that easily I can be in the conflict because maybe the judge who will decide the case which I represent will be at the next session of the Judicial Council because he wants to be promoted to a higher court. So this is really a tricky position. That's why I devoted the last slide to this, and I'm happy to discuss it with you. Thank you.
Okay.
Okay. My answer, maybe the word friends was too strong. It was about to find someone with whom you can cooperate or at least talk. Because then you will find that maybe the black color is not so black and your white color is not so white. And it will be more 50 grades of shade and you will find the right position. But I think, and I insist, there are people and institutions, or how to call it, which is not good to cooperate with. I mean like fascists, I mean like racists, I mean like, I don't know, organized crime. And of course, even in our professions, there are members who are connected, if not directly involved in these type of activities or in these very black colors. And then it's not even, and they can be in good suits and could be very friendly and to try to promote that they are very open-minded in this. But it's not good to cooperate with this type of people. So sometimes it's good to say yes is yes and no is no. But usually many people looks like some kind of enemies, and they are not. They are maybe scared. They have different, social experience and this. So try to not to be, as Paulo said, there are not two groups. We good people and there are bad people. You have to find some connections, and then you will find that you are people together. But there are bad people, of course, they are.
Good wisdom. Any last answer to that question, Pavel, or? No?
I think we are out of time. Everything was said. Maybe just one note. Irakli, I think we are missing those written regulations about conflict of interest of attorneys in the council. We need to work on that because I have witnessed attorneys who were praising and applauding judges when they were promoting them or accepting them with the clear intention that the judge will remember them when they will stay in front of the bench during their court case. So we really need that. That's my only comment.
Okay, thank you very much. So thank you to the organizers. Thank you very much to the funders of these projects, the USAID and Rule of Law Project in Georgia, and the International Network of judicial reformers. Thank you to everyone. Thank you especially to our 3 expert speakers for taking your time and giving it to us. We greatly appreciate it. And as I said, the recording of this session will go out to the many, many other members of the network as well. So I'm confident that it will be seen by many more than were present today. I think we learned that there is a freedom of being the outsider, and it can be taken advantage of in positive ways. There is something to bringing the perspective of other legal professionals to the regulation and reform of judiciaries. And there are dangers as well, as Andre mentioned, with the conflicts of interest that can arise in that context. But there is something special, as Pavel was pointing out, about being the outside mirror on the process and on the judiciary. And so maybe that is the contribution that private lawyers can make. And maybe we can hope to inspire a more positive, active role by bar associations themselves, something I think we have not seen up to this point. So we can hope and inspire and try to inspire that. All right, thank you all very much. Have a great day, evening for most of you. I've just started my day here, and we will see you again on the next time. Thank you all very much. Bye-bye.
Thank you.
Thank
Bye.
you, everybody.
Bye-bye.